Hello, my name is Stephen Shurtz. I'm a patent attorney with the firm of Brinks, Gilson & Leone, and today I'm here to talk about expedited patent examination. Many of you have inventions that you're interested in protecting because you know that the value to a company of its innovations is one of its most important assets. One of the problems that many people face is that it takes a long time to get a patent in the United States these days. And as a result, they feel there are lost opportunities because until they have a patent, there may not be licensing opportunities or opportunities to prevent competitors from entering the marketplace. So they ask them the question, how can I expedite this process and get my patent sooner? And that's what I'm here to address today. There are a number of considerations when you want to expedite patent prosecution. The first one that people look at is, well, just how long is it going to take to get a patent? And today, the current statistics are that it takes over 18 months just to get your first office action. And that first office action isn't by any means the grant of the patent. It's just the beginning of the process. After a first office action, then usually you'll have to respond in writing to the patent examiner, maybe amend your claims, file arguments, and continue back and forth with the examiner several times before he gets to the point where he's either willing to allow the patent to grant, or you reach an impasse and you have to appeal or sort of start the process over again. So this 18 months is just where you're sitting and nothing is happening to your patent application. And again, that's the average. There are many group art units that have longer than 18 months. So on average, it takes over 20 months to get to a final decision. So that's where either the patent office allows your case or they give you a notice, a final rejection, and indicate that they're not going to allow it. And you have to either appeal or you can file what we call a request for continued examination. Now, when you start factoring all of those cases in, so all the cases that the Patent Office has, including those where they've had a request for continued examination, the average pendency is 37, almost 38 months, and that's average. And we've done a survey. There was a number of companies that we looked at their average pendency, and it was over 4 years. So it does take a long time to obtain a U.S. patent. So what can we do about that? Well, the question is, what is the cost and what are the benefits? And does speed really matter, or does it matter enough? Some of the things that you'll think about if you have a product on the market and you're trying to get a patent for it and someone sees your product and a competitor comes out with a knockoff, you want to get your patent as soon as you can to stop that infringement. If you're a startup company, you may be interested in licensing your technology or even selling your technology to someone else. They might not value it as highly as they would have if you already had your patent. So that might be an important time to expedite prosecution. Of course, competitive advantages come. If you have a patent and other people know that, then they are less likely to enter the market with a competing product, and that gives you a greater share of the market and greater opportunity to profit from your invention. And of course, then there are some technologies where the life of the patent isn't really that important because technology moves on, and so the patent is only of any real value in the first 6-8 years of the life of the product. And in those, if it takes you 4 years to get the patent, you have very little time left before the technology has just moved on and there's no real benefit from having your patent. So I wanted to talk today about 4 different opportunities to expedite the examination of a U.S. patent application. The first one, and we'll spend most of our time on this one, is called the Track 1 program, or prioritized examination. We'll also talk about the patent prosecution highway, another avenue to expedite prosecution. Accelerate examination, we'll talk about that one. And then also a program called special status, or dealing with the health or age of the inventor. This Track 1 program, what is it? How long has it been around and what good does it do? Well, the program had been bandied around by the Patent Office for a number of years. In fact, was actually going to go into effect earlier in 2011. But because the American Invents Act was being subject of legislation at Capitol Hill, and also the Patent Office budget was constrained until that law was passed, they held off on implementing it, but finally it went into practice in September of 2011. So it's been around now for a few years, but I've found that not very many people are using it, and maybe that's because they're not familiar with it, and hence the reason for putting together this presentation. The program was modified in December of 2011 so that if you had already filed a patent application and you wanted to put it into a special status and have prioritized examination, you could file a request for continued examination, and with that request file a Track 1 prioritized examination request. So basic idea behind the Track 1 prioritized examination is that the Patent Office has agreed that they will advance the examination, take your case out of turn, as it were. So most times you file a patent application and it goes to the bottom of the stack, and the examiner picks up each application on the top of the stack and examines it, and it takes a while to get down to where your application is. So with this program, the idea is they're going to pick your case up earlier. They'll advance the examination of it. Another part of the program is that you will have enhanced special status throughout the pendency of the application. So this means that anytime that the applicant has to respond to an office action, once they've responded, then the examiner will pick up your response and give you the next office action on a special status before he picks up other cases. One of the real benefits of this program is it's not restricted to any special subject matter. There have been different programs the Patent Office has tried over the years. For example, green technology. At a time that was important, and the Patent Office said, well, let's any invention relating to green technology or counterterrorism. They've had a number of pet projects where they said, let's expedite examination of those. This program can be used for any subject matter, so that's a real benefit of it. The Patent Office has a 12-month target. When they set up the program, they wanted to have these applications completely finished within 12 months, a final disposition. On the other hand, they weren't confident enough that they would give you a refund if they missed that target. So there are also some important things to keep in mind, and that is that one of these Track 1 expedited examination cases can lose Track 1 status. So, and it will normally fall from the Track 1 process if, of course, the case is allowed. That's great. Or if you receive a final rejection, or you file a notice of appeal, or if you file a petition for an extension of time. So if you ever take more than 3 months to respond to an office action, then your case will lose its Track 1 status, that enhanced special status that you were granted. Well, what are the filing requirements for a Track 1 prioritized examination case? The program only applies to utility and plant applications. Now that's going to cover the bulk of most patent applications. The one major area that's not covered are design applications. So if you have an ornamental design where you want to protect the aesthetic appearance of a new project, a new product, that would be done through a design application, and design applications are not cannot benefit from this Track 1 program. But any subject matter of utility applications and plant patent applications can receive Track 1 benefits. The program applies if you filed a continuation or divisional application. So many times someone will file a first application, and then for some reasons they'll want to continue prosecution. They'll have more than one invention in their patent application. An examiner will give them a restriction requirement and indicate that they have to file a divisional application to protect the other aspects of their patent, of their invention. And those divisional applications, they can be filed as a Track 1 prioritized examination. There is one limitation that currently exists, and that is that the PCT applications cannot be filed under a Track 1 process. A PCT application refers to the Patent Cooperation Treaty. So if someone files a patent application in one country and they want to take sort of a special timeline to file in other countries, they can file what we call a Patent Cooperation Treaty application. And that gives them a fairly long time before they have to prosecute their application in those other countries. But unfortunately, if you've entered the United States, if you file in a foreign country and now you come to the United States and nationalize a PCT application, then in the normal process you could not use Track 1 for that. However, if you want to, you can file what we call a Section 111 bypass application and take advantage of your PCT filing date, but have a regular U.S. application, and in those cases you can use the Track 1 prioritized examination. Another limitation of these applications is they have to be filed electronically through the Patent Office's EFS web process, and a big consideration is that they have to be filed complete. You have to pay all of the fees at the time you file the application. You need all of the formal papers, the executed oath from the inventors. There's a Patent Office prescribed application data sheet, and that has to be submitted with the application. If there are excess claims, or if you're over 100 pages in length of your patent application, then there's extra fees for those. And all of those must be submitted with the Track 1 application at the time it's filed. I have included in the appendix materials a form that's the current version of the form that the Patent Office uses to file a Track 1 request, and there's a link on the right side of your screen that you can download the appendix materials, and you can take a look at that form. Some of the other pieces that information that you want to take into account as you think about using this Track 1 prioritized examination is the fact that it is limited to having no more than 4 independent claims or 30 total claims in your patent application. Now, for most inventors and most patent applications, 4 independent claims is sufficient, and 30 claims is is usually more than most applications contain. So this is not a major limitation. There's a requirement that none of the claims be multiple dependent claims, and also if you ever file an amendment that's considered non-conforming, so if you add a 31st claim during prosecution, then you will lose your prioritized examination status. Well, what is all this going to cost? As I mentioned, there's a trade-off. It's a cost versus benefit analysis. One of the major considerations is the Track 1 filing fee, and that's currently set at $4,000 if you're a normal-sized company or entity. Some companies, if they employ less than 500 people, qualify for small entity status, and there's now also a special micro entity that's been established by the Patent Office. So if you fit into one of these categories, you have in general reduced filing fees with the Patent Office and across the board, but specifically with the prioritized examination request, the Track 1 request, it's only $2,000 if you're a small entity or $1,000 if you're a micro entity. There is, in addition to that fee, there's a processing fee, and you have to pay the publication fee up front. However, currently the Patent Office has set the publication fee as $0, so there's no extra cost there. Now, these are in addition to the normal costs. So when you normally file a patent application, you have to pay an application filing fee, an examination fee, a search fee. All those total $1,600 normally. And if you're a small entity, you get basically half off of those filing fees. But the Track 1 $4,000 fee is in addition to the regular $1,600 filing fee for a patent application. So you'll spend altogether close to $6,000 to file a regular sized patent application if you want Track 1 prioritized examination. There's one limitation to the Track 1 process that up till now hasn't been a problem, and that is the Patent Office rules limit the program to 1,000 or 10,000 applications per year. And the reason they did this is they realized that if too many people filed these Track 1 prioritized examination, everybody would be entitled to go to the head of the line, and therefore nobody would be. So they set this limit and looked at their ability of the examiners to handle these cases. The 10,000 limitation is roughly about 2%. There were just over 500,000 patent applications filed in fiscal year 2012, so that 10,000 applications is roughly 2%. The Patent Office can revisit this number at the end of each year if they determine that the program can be expanded, or if they have to contract the program in view of the number of examiners they have and the amount of work that they're able to do. Then the Patent Office has flexibility to change that limit. As I mentioned earlier, this program is available to any applicant who has filed an RCE. Well, the request for continued examination. There is one limitation on that, though, and that is you must file your Track 1 request before you receive a first office action after filing your request for continued examination. And also, if you've filed the Track 1 request in an RCE, then you cannot file, and you have to continue examination again, file a second RCE. You cannot file a Track 1 request in that application. So there is a limitation of just one Track 1 request per RCE. Well, some of the things that you'll want to do as you consider filing a Track 1 request, first is you want to conduct a search and make sure that you are aware of the closest prior art. Because if you're asking the Patent Office and you're paying the money to expedite examination, you don't want to just do that to find that you've run into a stone wall. So conduct a search, find the closest prior art, and then prepare the patent application so that the claims avoid that prior art. And that way, when it gets to the examiner, if he finds the same prior art, you'll get a first office action allowance. Now, many times the Patent Office will find different prior art than what you've found, or you've drafted your claims to get around prior art you're aware of. Other prior art will then maybe be more relevant than that you found on your own. So, but again, it makes sense to try to draft your claims and prepare your application to have expedited allowance as well as just expedited examination. We, of course, recommend that you file a complete schedule of claims, that you have broad claims that you hope would be allowed, and then narrow claims that you feel like, okay, if that's all you can get, then fine, it's worth it, and the patent application can proceed with those narrow claims. So a good patent application that's going to be used under a Track 1 program will have the claims that are prepared in mind to being allowed quickly. One of the other considerations, as I said earlier, the 10,000 limitation on the number of patent applications that the Patent Office will consider, you might want to file early in the fiscal year. So the Patent Office uses October as their beginning of their fiscal year, and if you're getting towards the end of the fiscal year, you might want to wait or at least check to see if they've already reached that 10,000 limitation and not file a Track 1 request until after the new fiscal year. Another thing to do is watch out for informalities. So many times the patent applications are filed, and for some reason there's something that the Patent Office decides is informal and they bounce that. That all takes time, and that will limit how soon your patent application gets in front of an examiner. For example, if your abstract has more than 150 words in it, then the Track 1 petition will be put on hold until you get that informality corrected. I like to track the progress of an application if I'm using the Track 1 program, And so I will watch for when that petition is granted, that my Track 1 application has been allowed into the program. And then I'll call the group director and see if he can get him to assign the application to an examiner, because until it gets into the examiner's queue, it's not going to be picked up by the examiner. Once I get the group director to assign the application to an examiner, then I can call the examiner and set up an interview. One of the real benefits of the Track 1 program is that the Patent Office has recommended that the examiners will have a interview either in person or by telephone with the applicant or his attorney prior to even issuing the first office action. So in the cases that I've had, I've checked with the examiner. They know that they have a Track 1 case in front of them, and I'll ask them to set up an interview, and they will go out and conduct their search and examination of the case, and then sit down with me, and we can talk about what they found and how the claims look in view of what they found before they even issue a first office action. One of the other considerations, if you're interested in protecting your invention in foreign countries, is that if you use the Track 1 process in the U.S., then the patent prosecution highway can be leveraged to hopefully get allowance of your patent in other countries as well. And we'll talk more about the patent prosecution highway. Well, how well is this program actually working? As I mentioned, it went into effect in late 2011. The first statistic shows the Patent Office is so far they've had 16,000 of these Track 1 applications have been filed. The numbers have been going up. In fiscal year 2013, they had almost 7,000 applications. So we are getting to the point where they may start bumping into that 10,000 limitation. The petitions have generally, asking for Track 1 prioritized examination, have generally been granted at a fairly high rate. Nearly 90% of the petitions are being granted. And where they're not, it's because the applicants haven't completed all those requirements that we set out before in terms of including all the required papers, the fees, the application data sheet, things like that. Once the applications, these Track 1 applications get assigned to examiners, so far the Patent Office reports that they've had almost 10,000 final dispositions have been mailed, and 47% of those have been allowances. So the process is working. The average time it's been taking to get the application through the initial petition process is only 1.2 months. So 1.2 months from the time you file your application, you should have a decision indicating that it's been allowed into the Track 1 process and sent to the group art unit for normal examination. Then after that, it only takes just over 2 months to get a first office action. So that's a total of just over 3 months from the time you file your application on average till you receive a first office action from the examiner. On average, it's only taking just over 6 months from the time the petition is approved till you receive a final office action, which could be a notice of allowance, or it may be a final rejection and you'll have to continue prosecution. I wanted to give you an example, a real-life example of a patent application that I prosecuted using this Track 1 process. The first page of the actual patent, if you want to look at it, is in the appendix materials. So this application took 11 months from the time we filed the application until the patent issued. And if you look at this timeline I'm showing, you can kind of see some of the dates and how long some of the things took. So we filed the application in November, and within a month the Patent Office had granted the Track 1 status of the case. I then contacted the examiner, and within another month had a personal interview, sat down with the examiner and discussed the invention and the prior art, made sure they understood it. The examiner had already done their search, and so they were fully prepared to discuss the claims and how they stood in view of the prior art. So that first office action was then mailed within 2 months of the Track 1 application being filed. We then turned around and filed amendment in a little over a month, and we received a final disposition of the case, a final rejection, in May. We then had a telephone interview with the examiner and worked out for a few final things that needed to be resolved, filed an amendment after final in July, and received a notice of allowance in early August. We turned around, paid the issue fee right away, and the patent granted in October. So again, 11 months from the time we filed the patent application until we had the patent in hand. And as you realize, compared to the normal lifetime of a patent application, that's very quick. All right, let's turn to one of the other ways of expediting your patent prosecution. And this one is what we call the patent prosecution highway. So the route of the patent prosecution highway is a bilateral agreement. The U.S. has gone out to 27 other countries and have an agreement with each of those countries where they've said, if we allow an application in one of the countries, then the other country will pick up the case and have expedited examination for it. So you have some terms of art that we use in this, talking about the patent prosecution highway. You have what we call the Office of First Filing, so that's where your patent application is filed first for U.S. applicants. So the U.S. Patent Office would be the Office of First Filing. And then you'll file that patent application in other countries. So you'll have Office of Second Filing. The patent prosecution highway doesn't require any fee, but it does require you to use the search and examination results from the Office of the First Filing. So once the Office of First Filing has reviewed the application, examined it, and come to allowable subject matter, then you can use the patent prosecution highway to go to one of the other countries and ask for expedited examination. One of the limitations of this program is that you have to conform your claims in the Office of the second country to those that were allowed in the first country. So for some people that's a real problem. However, you always have the option, at least in the U.S., of amending your claims, making them narrow to conform to the allowed claims, but then file a continuation application with your original claims or maybe broad claims and prosecute those in a non-expedited fashion. We found that this program works well in Canada and some other jurisdictions. However, some places it hasn't really worked that well. Japan performs their own search and examination anyway, and many U.S. examiners seem to reject the conformed claims anyway. So even though the patent prosecution highway gets your case before the examiner more quickly than it would otherwise, your case would otherwise get there, it doesn't mean that it's going to necessarily be allowed, that they're going to just accept what was done in other countries. And I do want to point out, for those of you who are trying to protect inventions in Europe, Europe has its own expedited examination process. You can file a request for examination with expedited examination without any sort of fee. So it's you don't necessarily need to even tie yourself down to the patent prosecution highway. Now, one of the real problems with the patent prosecution highway, the way it's actually working, is that the Office of First Filing may not be the quickest. So you file a patent application in the U.S., the average pendency time normally, as we're saying, might be 4 years. By that time, the office, other countries have already picked up the application. So what we are aware of, there's another patent prosecution highway, and it's called the Motonani Pilot Program. And motatani is a word that comes from Japanese, and it refers to a sense of regret or a sense of waste for the intrinsic value of an object or resource that wasn't properly utilized. And so the idea behind this is that it's possible that an Office of Second Filing will actually have picked up the application and examined it first. And in those situations, we recognize, why not take advantage of that? Even though they're the Office of Second Filing, let's use a patent prosecution highway to expedite examination back in the other countries. So in those situations, you have you file a request at the Office of Later Examination, even though that may be the Office of First Filing, to use the examination results from the Office of Earlier Examination, so the country where you filed the application second. So it doesn't matter in this situation where the application was filed first, it matters who examined the application first, and then you can go and use the patent prosecution highway back to those other countries to ask them to expedite examination. This program was launched as a pilot program back in July of 2011. Initially had a 12-month pilot program time duration, but since then the Patent Office has indefinitely extended, so it's still a pilot program, but it looks like it's going to stay around. There are 8 jurisdictions that have agreed to use this program, so if your application has already been examined in Australia or Finland or Russia, you can then go to the U.S. examiner and ask for expedited examination under this patent prosecution highway. Let me kind of give you a schematic of how this would work. So you file your patent application in country A, and then as many of you are aware, you can file applications in other countries and claim priority to the filing date of that first country. But the second country may pick up the application quicker, and that becomes the Office B that we're referring to. And they're the Office of First Examination, and they grant the patent. They indicate that the claims are allowable. So at that point, you file your patent prosecution highway request back in the Office of First Filing, which becomes the Office of Later Examination, and ask them to use the results from the Office of First Examination. There's a sample of the patent prosecution highway request that you can use either if you're under the normal patent prosecution highway or under this Matatani pilot program, and that's also in the appendix materials that you can download. All right, let's turn to the accelerated examination program. So this is the third of the topics I wanted to address today, and deals with other ways that you can advance or expedite prosecution of your patent application. The accelerated examination program was conceived many years ago. The program's been around since about 2006. It's never really caught on, and so one of the problems was that it requires a pre-examination search and preparing what's called an examination support document. So if you're using a patent attorney to help you in prosecuting a patent application, in addition to preparing the patent application, then your attorney would have a search conducted, and then he would prepare what's called the examination support document. And that document has to go through the claims and go through the prior art and show where in the prior art certain claim limitations are found. One reason many people have shied away from using the accelerated examination program is that they're concerned that statements that are made in that examination support document will later come back to be used against them if the patent is ever litigated, that people will take statements in that document and say, well, hey, this shows your claims meant X or Y or Z. So generally it's not been a program that's been used. It's not restricted by subject matter, so it could be used by anyone in any type of field of endeavor. The program limited the number of claims to 3 independent claims, in total 20 claims. There was no fee other than the cost for your attorney to prepare the examination support document, other than the government only charged a $140 processing fee. Again, with this program, they had set a target of 12 months to have a final disposition of these cases. So you can use this program if you think it would be a benefit without paying the government the $4,000 for expedited Track 1 proceedings. You could use this. The last area we want to talk about deals with a special status that comes from the age or health of an inventor. So This program has been around since 1959, and I've had opportunity to use it. What you do in this situation is you file a petition for an advancement of examination. Again, you ask the Patent Office to pick your application up out of turn, ahead of the others that were filed before it. There's no fee required for this special status. The Patent Office requires either the applicant be 65 years of age or older, or that they have a state of health such that the applicant may not be able to assist in the prosecution if that prosecution ran its normal course. So you can file a petition and ask for special status. Requires you can submit the proof of age, a copy of a driver's license, or some sort of doctor's certificate if it's a medical situation. And the Patent Office of Petitions would then grant special status to those applications. Well, that covers the 4 topics that I wanted to address today. Just to kind of sum up, one of the things with the patent prosecution highway I had mentioned, if you do ask for Track 1 status in the U.S., you'll probably get an examination here in the U.S. shorter than where it would occur normally in foreign countries. So then you can leverage the patent prosecution highway and seek expedited examination in those other countries. If you have questions, I'd be glad to answer them. My contact information is part of the program materials that you have here. Thank you. Appreciate your time.